The opinions of the court in three cases. Number 86-492, Boyle against United Technologies Corporation. Number 86-995, Murray against Carter in a companion case. And number 86-1512, Pierce against Underwood, will be announced by Justice Scalia.
The first of these, Boyle versus United Technologies Corporation, comes to us by writ of certiorari to the United States Court of Appeals for the First Circuit. David Boyle, a United States Marine helicopter pilot, drowned when his helicopter crashed off the coast of Virginia during a training exercise. Petitioner, the representative of Boyle's estate, brought this suit in district court alleging under Virginia law that respondent Sikorsky Division of United Technologies, manufacturer of the helicopter, had defectively designed the emergency escape hatch system. The jury returned a general verdict in favor of petitioner and awarded him $725,000. The Court of Appeals reversed, holding that Sikorsky could not be held liable for the allegedly defective design because it had satisfied the requirements of what the court referred to as the military contractor defense. We granted certiorari to decide whether such defense exists as a matter of federal law and its proper scope. We reject petitioner's broadest contention that there is no justification in federal law for shielding government contractors from liability for design defects in military equipment. We have in the past recognized that in a few areas involving uniquely federal interests, state law is preempted and replaced where necessary by federal law, even in the absence of an explicit statutory directive so providing. We hold today that the procurement of equipment by the United States is an area of uniquely federal interest, and that a suit such as the present one directly implicates that interest. Still, as we have said in the past, state law will be displaced in a situation such as this only where it significantly conflicts with the federal interest. We think such a conflict exists where state tort law seeks to impose a duty contrary to that established by a federal procurement contract and where the design specified in that contract represents the type of governmental judgment that Congress sought to immunize through the discretionary function exemption to the Federal Tort Claims Act. We further hold that the selection of the appropriate design for military equipment is the type of discretionary function that will require the displacement of state law. Petitioner also challenges the scope of the defense recognized by the Court of Appeals. We hold today that liability for design defects in military equipment cannot be imposed pursuant to state law when 1, the United States approved reasonably precise specifications, 2, the equipment conformed to those specifications, and 3, the supplier warned the United States about the dangers in the use of the equipment that were known to the supplier but not known to the United States. Finally, petitioner claims that the Court of Appeals erred in not remanding for a jury trial on the basis of the elements of the defense announced in its decision. Because we find the Court of Appeals' opinion somewhat unclear regarding whether it believed that the elements of the defense were established as a matter of law, we remand for clarification on this point. Justice Brennan has filed a dissenting opinion in which Justices Marshall and Blackmun join. Justice Stevens has also filed a dissenting opinion. The second consolidated cases, Murray versus United States and Carter versus United States, come to us by writ of certiorari to the United States Court of Appeals for the First Circuit. Both cases arise from the same incident. Federal agents witnessed petitioners drive trucks, which they believed to contain marijuana, in and out of a warehouse in Boston. The agents eventually stopped the trucks, found them to contain marijuana, and arrested petitioners and their accomplices. The agents then returned to the warehouse and entered it without a warrant. They saw in plain view numerous large bales of marijuana and other evidence of crime. After about 5 minutes, they left the warehouse and did not return until they secured a search warrant. They searched the warehouse and seized the evidence. The question presented is whether the evidence seen by the agents during the initial search, which we assume was illegal, must be suppressed even though it was later discovered during the search pursuant to the warrant. The Court of Appeals held that it need not be. In our opinion filed today, we reaffirm what has come to be known as the independent source doctrine, which is a corollary of the exclusionary rule. Where evidence is discovered illegally, but is later rediscovered pursuant to a lawful means that is wholly independent of the unlawful means, the evidence should not be excluded. In this case, that means that if the information gained from the illegal initial entry did not affect either the agent's decision to seek a warrant or the magistrate's decision to issue a warrant, then the second search derived from a genuinely independent source and the evidence is not excludable. Because we are not convinced from the record, however, whether the warrant at issue here was independent in the sense we have described, we remand to the Court of Appeals with instructions to remand to the District Court to make this determination. Justice Marshall has filed a dissenting opinion in which Justices Stevens and O'Connor join. Justice Stevens has also filed a separate dissent. Justices Brennan and Kennedy took no part. Finally, Pierce versus Underwood comes to us on writ of certiorari to the Court of Appeals for the Ninth Circuit. One of the petitioner's predecessors as Secretary of Housing and Urban Development decided not to implement a program authorized by federal statute which was intended to provide payments to owners of government-subsidized apartment buildings in order to offset rising utility expenses and property taxes. Various plaintiffs, including respondents who are members of a nationwide class of housing tenants, successfully challenged that decision in lawsuits filed in 9 different federal district courts. After 2 of these district court decisions were affirmed on appeal, a newly appointed Secretary of HUD settled with most of the plaintiffs, including respondents. While the settlement was being administered, Congress passed the Equal Access to Justice Act, EAJA, which authorizes an award of attorney's fees against the government, quote, unless the court finds that the position of the United States was substantially justified. The district court in this case awarded attorney's fees to respondents under the EAJA, concluding that the Secretary's decision not to implement the operating subsidy program had not been substantially justified. The Ninth Circuit affirmed, and we granted the government's petition for certiorari. The case raises 4 separate issues. First, what standard of review should a court of appeals use when reviewing a district court's determination that the government's position was or was not substantially justified? We conclude that the Ninth Circuit was correct in applying the deferential abuse of discretion standard rather than applying the de novo standard and giving the determination plenary review. Deferential review is suggested by the EAJA's language and structure and as a matter of sound judicial administration. The next question is, what does the phrase substantially justified mean as used in the EAJA? The word substantial can have 2 quite different connotations. On the one hand, it can mean considerable in amount or large. On the other hand, it can mean for the most part or in the main, as, for example, in the statement, what he said was substantially true. We conclude that this latter connotation is correct and that substantially justified means justified in substance or in the main, that is, justified to a degree that would satisfy a reasonable person. This interpretation accords with related uses of the term substantial and is the standard that has been adopted by the vast majority of the courts of appeals. The third question is, did the district court abuse its discretion in deciding that the Secretary's position in this case was not substantially justified? We conclude that it did not. The government's arguments on the merits of the underlying issue do not command the conclusion that its position was substantially justified. Therefore, the award of attorney's fees is affirmed. Finally, we turn to the problem of calculating the amount of attorney's fees. The EAJA provides that fees awarded must, quote, be based upon prevailing market rates for the kind and quality of the services furnished, except that fees shall not be awarded in excess of $75 per hour unless the court determines that an increase in the cost of living or a special factor, such as the limited availability of qualified attorneys for the proceedings involved, justifies a higher fee. We conclude that the district court abused its discretion in awarding fees at a rate in excess of $75 per hour adjusted for inflation. In order to give any substantial effect to the statute's $75 cap on fees, the special factors referred to in the statute must be such as are not of broad and general application. The factors relied on by the district court here, such as the work and ability of counsel and the contingent nature of the fee, do not qualify. We therefore affirm in part, vacate in part, and remand. The Chief Justice and Justice Stevens join the opinion of the court. Justice Brennan has filed an opinion concurring in part and concurring in the judgment in which Justices Marshall and Blackmun join. Justice White has filed an opinion concurring in part and dissenting in part in which Justice O'Connor joins. Justice Kennedy took no part.
The opinion of the Court in number 87-168, Frisby against Schultz, will be announced by Justice O'Connor.
This case is before us on appeal from the Court of Appeals for the Seventh Circuit. It presents a facial First Amendment challenge to an ordinance enacted by the town of Brookfield, Wisconsin, that prohibits residential picketing. The district court held that the ordinance violated the First Amendment. A divided panel of the Court of Appeals affirmed. The panel decision was vacated, however, and the case was reheard en banc by the Court of Appeals, which ultimately affirmed by an equally divided vote. The town appealed here, and we postponed consideration of jurisdiction until the hearing on the merits. In the opinion filed today, we now reverse. Rather than decide whether appellate jurisdiction is proper, we choose to treat the jurisdictional statement as a petition for certiorari and have granted certiorari. The ordinance operates against speech in a public forum since it bans picketing on the public streets. The fact that the streets are residential does not affect the First Amendment analysis, but since the ordinance is content neutral, it is permissible if it leaves open ample alternative channels of communication and if it is narrowly tailored to serve a significant government interest. We conclude that the ordinance passes this test. In order to avoid constitutional problems, we narrowly construe the scope of the ordinance as limited to picketing targeted at a single residence. So construed, the ordinance leaves open ample alternatives, since marching, leafleting, or even more broadly focused picketing is not prohibited. The ordinance serves the significant interest of protecting residential privacy and the tranquility of the home. Within their own homes, individuals should not be forced to listen to speech they do not want to hear, since the very means of expression involved is inherently damaging to residential privacy. The picketing ban is narrowly tailored. The judgment of the Court of Appeals is reversed. Justice White has filed an opinion concurring in the judgment. Justice Brennan has filed a dissenting opinion in which Justice Marshall joins. Justice Stevens has also filed a dissenting opinion.